All right, so why were you over at that location? Because it appears from reading the stipulations that you, I'm sorry, Amanda Farias. Court is calling 2025 CR 006129, State versus Amanda Lynn Farias. Could I have parties announced?
Rick Pena for the state of Texas.
Joseph States Super Monica Godetto.
And are you Miss Farias? All right. Counsel, do you want to place on the record your representation of her?
All right, pause right here. This is the moment where everything gets real. The judge is about to formally explain the charge and punishment range, and this isn't just routine courtroom chatter. This is the legal equivalent of reading the fine print out loud. When a judge does this, they're locking in the record. You were warned, you understood, and you still chose to proceed. No surprises later, no "I didn't know" appeals. This is the court.
Did you understand it? Yes. Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor. State, we'll be proceeding on count 1, paragraph B. We will waive paragraph A.
Any
No.
objection?
No objection.
All right, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with burglary of a habitation. That's a second-degree felony. The range of punishment is any.
This right here is the biggest break of the day, and a lot of people watching won't fully appreciate it. Deferred adjudication means the court found enough evidence to convict, but is deliberately holding back the guilty verdict. Translation? The system is saying, we believe you did it, but we're giving you one last chance to prove you're not this person forever. But here's the catch. Mess this up, violate probation, slip even once, and the judge...
Yes.
Do you want a jury trial? You want to enter this plea?
And then plea.
All right, you have a right for your attorney to cross-examine witnesses that the state calls, or you can cross-examine them yourself. Do you want to do that, or you want to enter into a plea?
And then to plea.
You have a right to remain silent. Do you want to remain silent? I'm sorry, do you want to give up that right, or do you want to enter into this plea?
And then to plea.
All right. Court will find that, just 1 second.
No.
Anyone promise you anything other than the plea?
No.
Are you satisfied with the way you've been?
This is one of those moments that divides audiences instantly. On one hand, you're hearing self-awareness, reflection, even growth. On the other, this is after the damage is done. Judges hear versions of this speech every single day. What they're listening for isn't emotion, it's accountability, not excuses, not explanations, ownership. And notice how the court doesn't interrupt, doesn't validate, doesn't reassure.
Jesus Leyva, and the address of. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
Yes, it is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 7 years. There be 200 hours of community service restitution, the BIP course, TAP evaluation, follow our recommendations, and MRT. Is there a affirmative finding that's being requested in this case?
Per the code, this charge doesn't come with an affirmative finding, Your Honor.
All right.
It's for Title V offenses only, and burglary of habitation does not.
All right.
follow under
Well, I'll
Title V.
read the facts and we will see.
Yes, Your Honor.
All right. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then to the offenses charged in paragraph B, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
Yes, Your Honor. At this time, state offers into evidence its Exhibit 1 with all attachments.
No objection, Your Honor.
All right. After reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Our client's remorseful that this had happened. What's not in your the stipulations, not to your knowledge, is that there was some abuse possible molestation from the complainant against her child. And that led to this event.
Well, have there been charges filed for that allegation?
Not to my knowledge, Your Honor.
Any evidence presented to anybody for that?
This is the first time I'm hearing about it.
Okay, all right, you may proceed.
The client is employed, self-employed, does meal prep. There's a $1,500 fine. However, she may not have consistent income. I know this is for 7 years. I was hoping that the fine could be probated. She does do not professional home health care, like not a caregiver per se, but she does have to be around other people in a sense of making sure somebody doesn't fall over. If somebody needs something, she may help them. We're under the impression that this was not the affirmative finding of family violence. I had advised her that it likely would be imposed. And I would hope that you would follow the plea bargain agreement as written.
All right, so why were you over at that location? Because it appears from reading the stipulations that you were not invited.
Correct. Well, I was informed that he was there by him. This was ongoing abuse that I had been through with him. That he would stalk me. He, would find where I was. And that night I was with my friends and he was telling me that he was going to come looking for me and that he was going to find me. Anyways, it led on to the next morning. He was still contacting me. He told me he was there. I was telling him to leave.
This part often flies under the radar, but it's massive. An affirmative finding of family violence isn't just a label. It follows you. No firearms, no ammunition, limited housing options, restricted jobs. And because he waived his right to appeal, this deal is locked in. That's the trade-off with plea bargains. Certainty over risk. You avoid prison today, but you carry the consequences for years. So while the hearing ends calmly, make no mistake, this sentence doesn't...
He's currently out. He was guilty of putting his hands on my son and myself as well. He's out right now. I think deferred. I don't know. I couldn't tell you the legalities of that, but and that wasn't his only time. After I was arrested with this, he came to my house looking for me again with a gun and put it to my head. And because there was a restraining order, he had one on me. I ended up getting arrested. And so this is, even me on house arrest, he was still messing with me. So I understand that I wasn't supposed to be there or I went looking for it. But I think that just me being, provoked and going through what I was going through with him, I snapped, I guess.
Well, if he's on probation, shouldn't he have a no contact order as well?
Well, I believe that was all done prior to this taking place. His own separate case that he was placed on deferred was completed prior to this.
So he's completed probation.
He's not completed. He's on deferred at this time.
All right, so there should be a no contact order. Is that out of this court?
I don't believe so. No, it's in a different court.
Oh, okay. Well, I would have ordered a no contact, so
Sure.
maybe somebody should let probation know to reach out so there can be no contact.
That's right.
Do you all have children together?
No, ma'am.
All right, so there's no reason to have any contact with him.
Yes, ma'am.
Court is going to sentence you to 7 years deferred adjudication. There's a $1,500 fine that will be probated. There's to be no contact with Oscar Castro, Yemi, Vanessa, and Miss Abrams, that's Yemmi, Vanessa, Bello, Mondragon, Mondragon, Jesus Leva, Levya, and the BIPP course, TAP evaluation out of custody, follow recommendations. 200 hours community service restitution. I'm going to order the BIPP course. Once that's completed, 100 hours be deemed satisfied. The MRT course, once that's completed, 100 hours be deemed satisfied. Field visits 1 time per month for 6 months. Regular reporting by Zoom or in person. Regular random UAs. Proof of employment within 45 days. No employment as a home health care provider or with minors. Probation, is there anything else? Is there anything else you need from the court?
No, ma'am.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right, we can go off the record. In this court, to be successful on probation, communication is key. If there's an issue where he's bothering you, you need to let probation know. And maybe you can see if their probation officer can recommend that as a part of his conditions of probation, that he has no contact with you. And then if he were, that would be a violation of his probation. My understanding, his case is not out of this court. Otherwise, he would have had a no contact order. All right, good luck to you.
Judge,
You're welcome.
just one clarification. The meal prep that she does is not significant. She does the side thing of helping others, where it's not in a.
I mean, she's just
legal
doing meal prep and dropping it off.
She may assist somebody with in the house movements, not make sure they don't fall over. She is not a nurse. She's not licensed. She's not a home health care provider in her sense.
If she's doing that for people, I'm assuming she has regular people that she does that for. Am I correct?
Yes.
You will have to get a letter from that person or their family stating that they're aware that you're on probation for this and they have no concerns with your providing that service.
Okay.
All right, thank you.
Thank you, Judge.